The University of Georgia is suing one of their former players who transferred to Missouri for $390,000 in liquidated damages as a result of a breach of the name, image, and likeness contract that he signed with the University of Georgia Collective just a few weeks before leaving and transferring to the University of Missouri. So let's get into it. Let's break this down. Damon Wilson signed a 14-month name, image, and likeness contract with the University of Georgia, totaling about $500,000 in value if completed. After he signed that contract, and it appears took about $30,000, a few weeks later he transferred. And then the University of Georgia decided to press their rights in what could be a landmark case on name, image, and likeness matters in seeking a liquidated damages clause portion of the contract for $390,000 because he transferred, which they say is a breach of the contract. Now, the contract has an arbitration clause that requires the parties, if they have a dispute, not to settle it in the court system, rather to push it into arbitration. Apparently, Georgia tried to get Wilson to return the money and go to arbitration. He has either ignored them or failed to do so, so they are now suing him in an effort to compel him or force him into going to arbitration. At issue in the case is what we call a liquidated damages clause. All right, liquidated damages is the opposite of the type of damages we usually seek, where you have to go and you have to prove what you lost. All right, in a normal breach of contract context, you'd have to not only claim that the other party was breaching the contract or violating it, the terms of it, but also that you had damage that resulted from that violation or that breach. But liquidated damages are different. When he signed the NIL contract with the University of Georgia Collective, there's a clause in the contract that pre-negotiates an agreed upon amount of liquidated damages in the event somebody breaches that contract. So the party that is aggrieved or that is wronged does not have to go prove their measure of damages or losses. The reason this case could be such a landmark case in the world of college athletes getting paid is it because it tests the sufficiency of the clauses, the legality of the clauses, and the enforceability of the clauses that are becoming standard in these name, image, and likeness contracts between college athletes and the universities or their collectives.